All right, good evening, ladies and gentlemen. I'd like to welcome you all here and call to order the special meeting of the Development Commission. We'll be discussing the Issaquah Highlands Retail Site Development Permit, the Medical Office Administrative Site Development Permit, and the Highlands Storage Administrative Site Development Permit. And as I recall, our last meeting, Mr. Schneider, you were rebutting Lucy Sloman. Mr. Lell, you were rebutting Lucy Sloman.
Yes, I'm in the middle of my direct rebuttal testimony with our second rebuttal witness, Ms. Sloman.
Sorry.
Before I recommence, Mr. Chairman, if I could please briefly address two preliminary housekeeping matters.
Oh, please.
Thank you. First of all, I apologize, but I am required to briefly excuse myself this evening at 8:30 for what I hope will be a brief telephonic executive session for another city council. I'm fully intending and hoping that my direct questioning of Ms. Sloman will be completed by that time, and I am timing my departure at the same time that we typically break for these proceedings. In the unlikely event that our questioning is still ongoing, my colleague, Mr. Dunbar, will take over for me while I'm gone.
Okay, do you have an estimate of how long you're going to be?
At the very most, I would assume 25 minutes, but it could be shorter than that.
Okay, well, if you're okay, we'll just proceed. We'll take a break for 10 minutes and then we'll resume.
That would be perfect.
Resume.
Thank you very much. I appreciate your consideration. The second point is I believe that you're aware that the counsel for the applicant filed a memorandum or letter yesterday concerning the findings and conclusions and decisional process for this proceeding. That's still under review from my office, and we would respectfully request a reasonable time in which to file a written response if that's the Commission's preference.
Okay, what would that be?
We would suggest next Monday if
Okay.
that works for the Commission.
Okay. Thank you, it does.
Thank you. And with that, if there are no more preliminary matters, I'd like to recall Lucy Sloman to the stand. Ms. Sloman, could you please reiterate that and reaffirm that you continue to be under oath from your prior testimony?
I do.
I believe where we left off was we were about to introduce a new exhibit. I believe this is Exhibit C54, and I'll have my colleague hand that out to you, the applicant's counsel, and the Commission. For the record, this is a January 12th, 2018 email exchange between yourself and Patrick Mullaney. I believe that the larger email communication was referenced in Mr. Mullaney's testimony on January 16th. Are you familiar with this document?
I am.
Does the interlineated green text in this document reflect your response comments back to Mr. Mullaney?
Yes.
Could you please read aloud Mr. Mullaney's comments in the fourth bullet point on page 1?
The city would that IHIF's preliminary plat and SDP pre-applications are currently considered complete and vested to the development agreement.
And what was your interlineated response comment?
Based on the current draft of the replacement regs, if those change significantly, we'd have to revisit this. We all need that caveat. I see you have that below.
What did you mean by that response?
That we were in a process in which the council was considering what, if any, vesting language would be included in the replacement regs, and we did not know what the outcome of that would be, and that might change, make his statement no longer valid.
And what statement was that again that would be no longer valid in that event?
That the applications are vested to the development agreement.
Thank you. I'd now like to introduce a new exhibit, which I believe is C55. This is a document entitled Action Memo by the Major Development Review Team, and it is dated September 27th, or the written signature block indicates that it's September 28th, 2004.
Yes.
Are you familiar with this document?
I am.
Could you please describe this document and with respect to its purpose and context?
So an action memo was a tool that the Major Development Review Team developed to capture interpretations that were made that we wanted to make sure were documented for reference.
Okay. And what does this action memo accomplish or intend to accomplish?
Well, it was trying to identify how long permits were good and under what circumstances they might expire.
And can you elaborate on that, please?
Well, I think there were a couple of things that we were trying to get at. One was that during the term of the development agreement, we were not applying time-related expiration. The municipal code limits land use permits to 3 years, and but that was because the underlying code provisions could change. But because the standards in the development agreement were fixed for the build-out period, then there wasn't that likelihood, except if a modification, either a major or minor modification, took place. And so we were trying to explain how we were going to approach that topic.
And could you please read aloud the proviso beginning with the word provided, however, in the fourth to final line of the summary of action provision
Yes.
of this action memo?
Provided, however, that if at any time either development agreement is terminated, provisions may be made to establish an expiration period for outstanding permits as allowed through the termination process.
And what was the reference in that statement to either development agreement intended to mean?
As you may notice up at the top, where it says project, both Issaquah Highlands and East Village, which is now called Talus, both of the boxes are checked for both of these. So this action memo applied to both of these development agreements.
So is it your understanding then, Ms. Sloman, that the summary of action provision of this memo indicated staff's position regarding the status of approved permits under the development agreement
Yes.
following the termination of the agreement?
Yes, I was just rereading the language because what it refers to is outstanding permits, and that isn't a defined term. But I think that when you read the piece above it in which it's talking about that they're valid during the construction process, including acceptance and closeout, it's talking about the full arc, even beyond permit issuance, but the complete closeout of the entire project. And so I think it was trying to address if there were permits that were not past that complete process, that it might be necessary to address those during the termination process.
By the date of this action memo, which is again the September of 2004, had IHIFC acquired its property?
Not that I'm
Issaquah
aware of,
Highlands?
no.
Had it approached the city with any development proposal by that point?
No.
Thank you. Ms. Lohman, did you hear the testimony made by the applicant's various witnesses in this proceeding to the effect that the city discriminated against IHIFC in favor of other project applicants under the 1996 development agreement?
Yes?
To your knowledge, was there ever any deliberate discrimination by the city to this effect?
No.
Do you specifically recall the witness's testimony concerning the Polygon Issaquah Highlands projects?
Yes?
What procedure was used by the city to process Polygon's plat application? Was it the procedure under the Issaquah Highlands Development Agreement, or was it the new process specified by the replacement regulations?
We used the process that was in the Issaquah Highlands Development Agreement.
Were you involved in the decision to process the Polygon plat under that process?
Yes,
Did you consult with Mr. Niven regarding the procedure to be used for processing the Polygon plat?
at one point, yes.
Okay. Did you consult with legal counsel?
No.
In your opinion, Ms. Sloman, was the decision to process the Polygon plat under the development agreement a mistake?
Yes,
Could you expound on that, please?
sure, I'd like to. As Mr. Niven testified, this was the first time we had terminated development agreements. I was approaching it as if it was all or nothing, which I've since learned is incorrect, that the standards can terminate, but, or the replacement regs take into, sorry, I'm not saying this very clearly, that the replacement regulations process is what comes into play, even if a project is determined to be vested under the development agreement. And at the time, for preliminary plats, we actually preferred to use the replacement regulation process. We thought it was better for the applicants and a cleaner process, and we chose not to use it because we didn't think we could.
Did any party ever challenge the city on this point or otherwise raise this procedural issue during the Polygon review proceedings?
No.
When was the final decision on the Polygon plat made?
Well, there were actually two plats. There was the Westridge North single-family plat, and that one concluded, I think, around July of last year, and the Parcel D preliminary plat, which concluded early this year.
Was either decision for Polygon appealed by any party?
No.
Did you deliberately treat Polygon or any other project applicant preferentially?
No.
Are you aware of any such preferential treatment by other city staff members?
No.
What is the UDVC?
UVDC is the Urban Village Development Commission. Like this Development Commission, they hear similar kinds of permits, but we're focused on the projects in the urban villages, which are the areas that have development agreements.
Was the UVDC involved with the Polygon plat
Yes.
review process?
Yes, for both plats, they made a recommendation to council.
And was that process the one specified under the development agreement?
Yes.
What is the current status of the UVDC?
They're essentially done. We had a meeting in March of this year in which we heard what we expect to be the last action that they were to take. The mayor showed up and thanked them. Thank you notes were handed out both to them and from them. So it seemed fairly conclusive.
Just to clarify, is the UVDC effectively disbanded?
Effectively, it won't be officially disbanded until action is taken by council. But we have nothing on the schedule, and we don't expect to reconvene them.
Thank you. I'd now like to introduce a new exhibit, which I believe is C56. This is an email string culminating in a September 11th, 2017 email message from Nick Abelnor to Jean Lynn with yourself and David Avenel Jr. listed as courtesy copy recipients. Are you familiar with this document?
Yes.
Could you please describe this document?
Well, it started earlier in the summer of 2017 when both David Avenel and Nick Abdelnour were trying to get a better understanding of schedules for their projects. David had laid out a schedule, and I was identifying that we hadn't agreed to that. And because many of the permits that they were identifying were to be processed at that time by Jean Lynn, I had asked her to respond, and she did on September 8th, to which Nick responded, which is the ultimate email in the chain.
And how would you characterize Nick's response in that ultimate email in the chain?
He was very unhappy.
Why was he unhappy?
Because the timelines that Ms. Lynn laid out didn't meet their business model and their needs for getting permits processed.
So if I understand you correctly, Ms. Sloman, Mr. Abelnor, who's working for Polygon, was complaining to the city about the city's processing?
Exactly.
Thank you. Were these complaints consistent with communications received by the city from other project applicants at the time?
Yes.
I'd like to introduce a new exhibit, which I believe is Exhibit C57. This is a February 2nd, 2015 email message from Elena Robertson to Mike Martin. Are you familiar with this document?
Yes.
Who is Elena Robertson?
She was working for Polygon and was kind of the project manager for the permits, much the way David Avenel was in the previous email.
And who is Mike Martin?
He was a planner working for Development Services.
Could you please describe this document?
Well, Elena was laying out when they would plan to submit 4 different permits, which included both site development permits and plats, and when they planned to have the hearings for those permits, as well as construction permits.
Okay. The document contains pen and ink interlineations. Did you insert those?
Yes. Part of the reason I did it was because I found, for instance, where it says TH South Site Plan Approval, and it says April, APR-15, you could read that as April 15th, and in speaking with Mike, it was, in fact, that was April of 2015. And so that was my way of just understanding what the content was.
Do you have further communications with Polygon following this email exchange regarding this topic?
I don't know. I assume so, because I don't think we agreed to that timeline.
So is it your testimony then, Ms. Sloman, that Polygon had requested or proposed a specific processing timeline for its various projects, and the city essentially rejected that?
Right. I mean, they were proposing 4 months for plats and 2 months for SDPs, and that was just not enough time to get through the process. In fact, the SDPs took more like 5 to 7 months, and the plats took over a year or more to get through the corrections and the processing necessary.
So the plats for these other projects took over a year?
Yes.
Thank you. Could you please describe, in your own words, how the city processed or otherwise treated Polygon's various applications in relation to how IHIFC's applications were treated by the city?
Well, we were processing them all at the same time. We were making sure they were complete, asking for corrections, trying to figure out when they would go on various schedules, which staff members would work on them. We were doing that for all the permits that were in front of us.
Was one of the Polygon applications a short plat?
Yes.
Can you describe that, please?
Sure, and I'm glad to speak to that because I think there was some testimony that was misleading and/or incorrect. Mr. Mulaney, for instance, referred to Polygon's short plat as a preliminary plat, and there's a pretty substantial difference between the two.
What is that difference for purposes of processing?
Sure. A short plat is an administrative decision, so that means that staff can make the decision. We issue a notice of decision, but it's a relatively straightforward process, whereas a preliminary plat is a lengthier and more complex permit, and the decision maker is either the council or the hearing examiner, depending on where it is in the city. In this case, with Polygon short plat, it was submitted early in 2016, and the first set and only set of comments were issued in May of 2016. They were relatively minor comments. It was very clear to see how they would be resolved. And so while it would have been better to have the short plat approved before the site development permit went to the Urban Village Development Commission and then on to the council, the staff had a very clear understanding of what the outcome was going to be and what it was going to take to correct the preliminary plat. Shelter's preliminary plat, on the other hand, being a full preliminary plat, was much more complicated. Because we aren't the decision maker, we don't know what the outcome is going to be. The plat showed a public access easement on areas that had parking in the corner of a building. We had no idea if that was going to be released. And so there was a great deal more uncertainty that came with a preliminary plat than a short plat.
Thank you. Do you recall the testimony in this proceeding regarding the city's alleged efforts to preferentially facilitate the project application filed by John Haas and/or CitySurf?
Yes?
Do you agree with that testimony?
No?
Could you please describe the CitySurf project?
So the CitySurf project was, I think it's around 13,000 square feet on about an acre, maybe a little more. It was a single-story building with a surface parking lot. So it was fairly straightforward permit. We actually had the staff person, it was originally assigned to Jean Lynn, and then afterwards, when it became clear that there were too many permits on Ms. Lynn's plate, we had Valerie Porter take on the permit. Valerie hadn't actually done staff reports before, and so we asked her to take this on, and we're trying to train her by reviewing and writing the notice of decision for this.
I'd now like to introduce a new exhibit, which I believe is Exhibit C58. This is a September 22nd, 2017 email exchange between yourself and John Haas. Are you familiar with this document?
Mm-hmm. Yes.
Could you please describe the content and context of this document?
Well, I'd received a phone call from Mr. Haas. He was frustrated at how long his permit was taking, and so I had done some research, speaking to the planner and to the then permit oversight manager, Christopher Wright, and was responding to Mr. Haas to give him a sense of what was happening with his permit.
I believe you just testified that Mr. Haas was frustrated?
Yes,
How did he manifest that frustration to the city?
He was very upset. He thought that we should have been done a long time ago. He didn't understand what was taking so long, and conveyed that in his voicemail to me.
So his voicemail to you complained about the city's processing of his project application.
Exactly.
I'd now like to introduce a new exhibit entitled the C59. This is a multicolored chart.
Thank you.
Ms. Sloman, did you prepare this document?
I did.
When did you prepare it?
A month or two ago when we were preparing for rebuttal.
Why did you prepare it?
Well, there were a lot of comments made and some exhibits shown during the testimony of Ms. Heim, and I wanted to have a tool that would try and explain what was happening in, I thought, a more accurate representation.
Could you please then explain the various references and timeframes on the chart? And for the record, it looks like the graphic representation of this document that was projected onto the screen might be a little blurry.
Okay.
Is there a way to sharpen the focus of that for the commission's benefit?
I don't know. I'm not seeing it, sorry.
That's fine, Ms. Sloman.
Mostly what I want to do by projecting it is be able to show you where I'm looking on the chart because there's so many cells. Unfortunately, you'll have to be looking at your chart to actually see the content, but at least we'll know the pieces that I'm pointing to.
And each commission does have a copy now, so.
Okay,
Thank you.
great.
If you could please proceed with your explanation.
So, as I mentioned during shelters, particularly Ms. Heim's testimony, there were many different permits by Polygon, Shelter, Block 19, and City Surf that were mentioned. And so what I did was try and summarize 5 years' worth of permit activity in a single chart, which is why it's very tiny. The sources that I used were my notes and my calendar and our permit database to try and show what was happening. These are meetings and permits specifically related to the development of property. They are not meetings about the development agreement extension or a new development agreement that have been mentioned. The orange bars that you see up here across mark years. Each row represents 2 weeks of the particular month that's identified. If there are 2 actions that happen to the same permit in the same 2-week period, then you see that there's a blank on the left, where instead of having, say, 1 to 15 May, 6 to 30 May, you can see that there's a blank cell. That means that there were 2 things that happened in that 2-week period for the same permit, and there's a handful of those that happened. So the first thing I'll point out, about midway down on the left are the cells right next to the date. These have to do with staffing. And you can see that in October 2016, we had 4 staff members. And then starting in November, we went down to 3. And then in December, we went down to 2. And then in March, we went up by 1. This was a planner who had 1 year of experience. And then we went down to 1 planner, and then it wasn't until July 2016 that we were back up to being fully staffed. So this is about 9 months in which we were not fully staffed. But even when we were fully staffed, They were all new to the city of Issaquah. Half of them had no Washington experience. They didn't have any experience with our codes or the development agreements, and I only had one senior planner. So that would have repercussions for quite a while. If you look up at the top, so the language right up here between the two orange bars says transfer from MS to Polygon, which means that as far as I have found, that was when Microsoft sold the property to Polygon. And then the gray bar, a few lines down, is based on a newspaper article that I think we were sent that identified that Lion Homes had purchased Polygon and that there were people leaving Polygon to start a new company, which became Shelter. And around that time, you can see there are quite a few meetings in this area that are identical under the general planning for Polygon and the general planning for IHIFC. So at the very, I forgot to say this, so I'm sorry. The very top row, you can see it has Polygon, and then below that, the specific permits, then IHIFC and the specific permits, Block 19 and City Surf. And then the next rows are the permit number, the permit type, and then some statistics about that particular project, including the size of the site, the size of the buildings that were going on it, the number of dwelling units or square footage, and whether it was a structured parking or surface parking, just as a way of giving a sort of sense of what the project was composed of. So what you can see is that around the time, not too long after Shelter bought the property from Microsoft, there are all these green meetings up here at the top and the reason they show up in both of them, because at the time, Polygon and Shelter were the same group of people. That was a single ownership. And then after Lion bought Polygon and IHIFC split off, there's a gap for Shelter between when we were talking about permits. The last meeting was in early July 2014 until, with one exception, we didn't really meet until March 2017, so almost 3 years of time. There are several themes that I'm going to just introduce, and then I'll show you in more specifics. One of the themes is don't wait till the last minute, because everyone wants the same thing. When something like a development agreement is ending, all the property owners are going to want to get their permits done and try and get some predictability. Where we had more meetings up front, things went generally more smoothly. And for most permits, they were complete the first time they were submitted, not all of them, but most of them. So
I have an objection to this run-on narrative. I understand it's appropriate to explain the chart, but if we're going to be making specific testimony about the meaning of the chart, then I think it needs to be question and answer and not a lecture.
Mr. Chairman, I've asked Ms. Sloman as the witness to explain the chart. That's, I believe, what she's attempting to do. She indicated it's got numerous cells, and that does require some meaningful explanation.
Well, she's now moved on to themes and talking about don't wait till the last minute. That's not talking about the content of the chart.
So I would be glad to move back to the content of the chart.
Thank you. What you can see, for instance, that for Polygon, for their Westridge Single-Family South, they were holding quite a few meetings up front. That actually was not just related to that plat, but was actually related to their entire property.
And then after they began to get a sense of how they wanted to develop the entire property, they specifically focused onto the plat. For Block 19, a similar point that they held quite a few meetings and then made their submittal. For Block 19, also, they were very focused on getting their permits in by the end of the year, and you can see over on the right where that happened. And they started in late 2016 talking to us because they wanted to be assured that they would have their building permit in by the end of the year.
So again, I repeat the same objection. I think this is marginally relevant at best to the subject of this hearing, but again, the witness is just saying whatever she wants to say about the chart and not responding to questions from council. So we need to have a question and answer format so that objections can be made.
Mr. Chairman, I would respectfully note that the entire issue of the Westridge applications was one that was introduced into this proceeding by the applicant. This is very clearly within the scope of the city's permissible rebuttal, and Ms. Sloman is simply attempting to contextualize the chart that she has created to explain the similarities and/or differences between the city's processing of IHIFC's various permits and those submitted by the other applicant.
And I didn't object on relevance grounds. I pointed out it was marginally relevant, but it still needs to be question and answer and not the witness simply saying whatever she wants to say about it.
Okay. Okay, would you please try to question and answer questions as opposed to maybe editorialize or get further into the depth of the chart?
Ms. Sloman, were you in the hearing room to listen to Ms. Heim's testimony concerning the city's treatment and processing of IHIFC's various permit applications?
I was.
And were you in the hearing room to hear the testimony of Ms. Heim and I believe Mr. Mullaney regarding the city's treatment and processing of other project applicants?
I was.
And their various permits? In attempting to summarize as best you can, how does your chart address that testimony and rebut it?
Well, specifically, the exhibit that Shelter presented, S88, which showed a series of permits that they were including City Surf, Block 19, Polygon, and Shelter. They had given a sense of how long those permits had taken and how they thought that was unfair. And I think 2 points to make. One is that there were errors in that. This is shown at the very bottom row in which, sorry, it's, you can see that for Block 4, for instance, down at the very bottom, S88 showed that it was submitted April 27th, which is correct, but that it was approved May 16th, when in fact it was approved September 7th. Likewise, although not as incorrect, the townhomes north were shown being approved on S88 May 10th, and in fact, it was approved May 21st. Also, what that exhibit did not show was the number of permits that were being processed at the same time, and that there was a huge number of complex permits, and that's part of why Appendix L says if you have appropriate staffing, because the number of permits and the experience of the planners that we were able to hire did not allow us to simultaneously move everything through instantaneously.
So in summary, Ms. Sloman, you have reviewed applicant's exhibit S88, correct?
Yes.
And do you agree with that exhibit?
No.
The reasons,
Because I think it's misleading, because it shows each permit independently of all the other things that are taking place. I mean, this chart is just a snapshot of things that were happening in a certain area of Issaquah Highlands, not the entire city or even the entirety of Issaquah Highlands. And second, it had errors in it. It didn't, some of the dates were incorrect. And third, it only started as soon as you submitted a permit. It didn't show any of the pre-work that was done to help improve the way the process went.
thank you. And for the record, is it your position that the chart that was just introduced into evidence as Exhibit C59 is accurate?
To the best of my abilities, I was trying to compile 5 years' worth of data, but yes.
Thank you. Ms. Sloman, do you recall the testimony in this proceeding concerning the city's use of the Development Commission process for IHIFC's SDP, ASDP applications?
Yes.
Following the adoption of the replacement regulations, did you ever communicate to IHIFC that the city would process IHIFC's SDP and ASDP applications in a manner that did not involve the Development Commission?
I don't remember talking about that after the replacement regs were adopted.
Following the adoption of the replacement regulations, did you communicate with Mr. Niven regarding the procedures that would be used to process IHIFC's SDP and ASDP applications?
Not right away.
Was there a miscommunication between yourself and Mr. Niven regarding this issue?
Yes, when we finally had a conversation about it, I realized that I was again using the development agreement process and not the replacement regulation process, which I should have been using.
Did you originally work to prepare administratively issued notices of decision for IHIFC's SDP and ASDP applications before you and Mr. Niven discussed this procedural issue?
Yes, we received IHIFC's letters saying they would not update them, update their applications to comply with the development regulations, I think on the very last day of May. And in early to mid-June, I had already started reaching out to other city staff to find out if there was a template for Development Commission staff report for denial. That was a relatively, well, it was actually, none of us had a model staff report. And so I was both doing that research and then beginning to try and assemble the pieces to figure out what would be an appropriate way to construct that staff report.
When did your clarifying discussion, if I can call it that, with Mr. Niven occur?
Towards the end of July or beginning of August.
Following your discussion with Mr. Niven, did you work expeditiously to process IHIFC's ASDP and SDP applications through the Development Commission?
Yes.
Could you please describe your efforts in doing so?
Well, again, we were trying to decide what were the essential pieces that would need to be in there and the attachments, assemble them, and coordinate, get the Development Commission meeting established, send out all the notices that were required. There are a lot of moving pieces to setting up a Development Commission meeting.
Have you deliberately delayed these proceedings in any manner?
No.
Have you ever intended to mislead IHIFC regarding the procedure that would be used to process its ASDP and SDP applications?
No.
Sloman, did you hear the testimony from the other witnesses regarding the alleged delays by the city in processing IHIFC's project applications?
Yes.
Did the city always anticipate or intend for the replacement regulations to be adopted in March of 2018?
No.
When were they originally anticipated to be adopted?
When we, I think either when we brought the first draft forward or in the spring of that year when we were doing some informational meetings, we had thought that it would be adopted in the early fall of 2017. By the time we were full into going through the public process of discussing the drafts with the commissions, it became apparent we weren't going to meet a fall deadline, and so we had moved it to December 2017.
What were the reasons for this delay or postponement?
Well, partly it was the complexity of the work we were trying to do. As I said, this is the first time we'd ever done this. And then we were also trying to respond to a great many requests. We were dealing with 2 property owners, Shelter and TriMet, that had a lot of questions and requests and research projects. And then once we got to council, we were also, and actually, in fact, even before then, IHIFC was asking that the process slow down.
I'm sorry, could you clarify that or state that last point again?
Well, they were, I know in writing, possibly verbally, asking that the process not go so fast.
Who's they?
Shelter Holdings, IHIFC.
And what process were you referring to?
The adoption of the replacement regulations.
Shelter Holdings tried to postpone the adoption of the replacement regulations. Is that your testimony?
I'm not saying that I don't know what their goal was, whether they were trying to postpone it or not. I'm just simply saying that the message that they gave to council in particular was, slow down, this is going very fast.
And were those communications by IHIFC, in what general time frame were those made?
So we got to council in October 2017, and we were, I think, at least by November, hearing that on a regular basis. But I think possibly even in the fall of 2016, when Director Niven made his first presentation to the Land and Shore Committee and laid out a schedule, having this adopted in, late summer or early fall of 2017, that message was given in one of their letters, responses to that presentation.
Are you familiar with the dates upon which IHIFC originally submitted its applications for its various ASDPs and SDP?
The pre-applications?
Just the applications for the actual submittals.
Generally, yes.
In your opinion and experience, Ms. Sloman, would it have been likely or even possible for those applications to have been approved by the original anticipated adoption date for the replacement regulations?
No.
Why not?
Well, I mean, we were talking about doing that in early fall. The preliminary plat was submitted on August 1st, 2017. And even if we had done what I call straight time, where it was just, there were no corrections, no changes, no additional information, that permit wouldn't have been done until after Thanksgiving.
Thank you. I'd now like to shift to an exhibit that there's been much testimony about in this proceeding, and that is S9. I'm going to ask Mr. Dunbar to hand you a copy. This is already in the record.
Okay.
This is the commercial and multifamily building permit submittal requirements that I think has been variously referred to as the web document throughout
Okay.
these proceedings. Are you familiar with this?
Sort of, yes.
To your knowledge, Ms. Sloman, is this document referenced anywhere in the 1996 Issaquah Highlands Development Agreement?
Not that I'm aware of, no.
To your knowledge, did you or any other staff member ever indicate your intent to enforce the land use permit NOD issuance requirement on page 2 of that document against IHIFC?
No.
Did IHIFC ever refer to this document in its dealings with you or other city staff members before the current proceedings in this Development Commission?
Well, we likely talked about it when we were going through our various meetings and coordination. When they would say, what do we need to submit? We would say, look at this document. But at the same time, we, encouraged applicants to talk to us, ask us questions. If submittal requirements didn't make sense, we expected to go through and identify if some pieces didn't make sense to them, whether they were actually necessary or not.
Did you or any other staff members, to your knowledge, ever tell IHIFC that they could not submit a building permit application until after a land use permit notice of decision had been issued?
No, I don't think we ever talked about building permits.
Could you then turn to Exhibit S-118? This is a previously introduced document that the applicant submitted into evidence for this proceeding.
I'm sorry, which exhibit?
S-118. I believe it's the Clark Design Group memorandum.
I have a copy
I
here.
was going to say, I don't think I have it here.
It should be in that August.
Okay. Okay?
Were you in the hearing room to hear the testimony regarding this document?
Yes?
Can you please turn to section 2.5
Yes?
and read that aloud?
Dual track ASDP and building permit. LS noted that the city does not typically allow a dual track between the ASDP and building permits. The building permit may be submitted once the ASDP is approved.
Could you please respond to that statement?
Well, I think the important word there is probably typically and allow. That's two words, actually. We sometimes had building permits submitted while ASDPs were in review. This meeting was in September 2016 at our very preliminary meeting when we were just laying out a larger framework. We would typically work with applicants. I know that Trammell Crow, who was not the Sumitomo, was the owner of the property. Trammell Crow was the developer. They were asking a lot of questions about when they could submit building permits, and so we were talking to them about various timing along the way.
Ms. Sloman, do you recall ever telling that consultant or that applicant group that they could not submit a building permit application unless and until a notice of decision for land use purposes had been issued for the property?
I don't remember saying that, no.
Thank you. If IHIFC had filed one or more building permit applications for its property, in your understanding, would those applications have been considered vested pursuant to state law?
Yes?
To your understanding, could IHIFC have submitted building permit applications for its property without waiting for a land use decision or notice of decision?
Yes, I mean, that's been quite a bit of discussion here. In 1801-050, it says that you can submit a building permit at any time. We have had applicants both before shelter and currently who have just gone ahead and submitted their building permits with their land use, while their land use permit was in process or simultaneously with their permit.
Did the city reject those building permit applications for those other applicants?
So the one that was prior to shelter was the Vale project, which was touched on briefly at our last hearing.
Could you please describe the Vale project?
Sure. It is a multifamily project. I think it's 5 stories high, 110 units. They were, their permit was at the Development Commission at the same time, or actually, the moratorium was enacted in early September, and their land use permit went to the Development Commission later in that month. We are required to hold a public hearing after the enaction of a moratorium. They knew that was coming up, and they were concerned that the result of that might be that they would not be vested and would be held up by the moratorium. And so they submitted a building permit to get vested. That permit was not determined to be complete, but it did not have to do with the fact that their land use permit was incomplete. It was due to the fact that they had not submitted all the components of the building permit.
So if I understand your testimony, Ms. Sloman, the city did accept building permit applications from other applicants, including Vail, the Vail project, without waiting for an NOD to be issued for the underlying land use permit?
Right. We accepted it and then reviewed it for completeness, which it was determined not to be complete. More recently, because of concerns about enacting new development standards in Old Town, an applicant submitted both the building and land use permits simultaneously, and they were both determined to be complete.
Did IHIFC ever attempt to submit a building permit application for its property?
Not that I'm aware of.
Could IHIFC have filed its SDP application for its property and then subdivide the property later at some point?
Yes. I mean, when we do an SDP, we do it for the entire property, and so they could have started with a permit, a site development permit for the whole property, and then later on either short platted or done a long plat or a preliminary plat, dividing it into the blocks. Or they could have even dedicated roadways as a means to subdivide the property.
Are you aware of anything in the 1996 Issaquah Highlands Development Agreement or the city's code that would prohibit that approach?
No, we've had it happen before.
In what context?
Typically smaller projects where someone wanted to get to building permit, but then also wanted the property subdivided. We've also had lots created through the dedication of roadways rather than part of a platting process, which happened across the street from where this is, where Safeway Fuel and Home Street Bank are located.
Mr. Chairman, we're at the 1 hour point, and I'd be happy to break if that's the commission's preference. I'm at I think, a logical breaking point, but I'm also happy to keep going if that's what the commission would prefer.
I think we would like a break, so let's take a 10-minute break.
Thank you.
All right, I'd like to call the meeting back to order, please.
Ms. Sloman, did you hear Ms. Himes' testimony regarding the pre-application issue?
Yes.
Could you please describe what a pre-application conference is?
It's a submittal of, kind of an early submittal of the project that lays out many of the pieces so that both development services and other reviewing departments can give feedback to the applicant.
And who typically attends a pre-application conference?
The project engineer, the DSD project engineer and planner is sometimes the manager or the fire marshal, depending on the content of the project.
And how long does a pre-application conference typically last?
An hour, hour and a half.
Does a pre-application conference typically result in some type of a written summary or report or other document?
Yes.
Who prepares that?
Typically the planner.
And is that typically distributed to the applicant team?
Oh, yes. I mean, that's the point of it.
Is there a practical reason or benefit in your understanding for a project applicant to engage in a pre-application conference?
Sure. I mean, they're getting feedback early on from the departments that will be making the decision on the permit.
In your opinion and expertise, Ms. Sloman, does participating in a pre-application conference typically expedite and facilitate the review of an underlying permit application, or does it slow the process down?
Well, it's a step along the way, but I think the whole point is to provide that early feedback before you dive into a full submittal so that your submittal is closer to something that can be approved.
Did IHIFC object to the pre-application requirement for its ASTP and SDP applications?
Yes, late in October, maybe October 26th.
And did the city retract that requirement to IHIFC?
Yes, sometime maybe 5 to 10 days later, in email and conversations, we concurred that it was optional. We felt it was an important part of the process, but that it was an optional part of the process.
By the time that IHIFC objected to that pre-application conference, had IHIFC already submitted one or more of its ASTP or STP applications?
Yes, it had submitted two pre-apps prior to that objection. And then after we said that we did not, we concurred that they were optional, they continued to both submit and hold pre-app applications.
So IHIFC continued to hold pre-application conferences even after the city informed IHIFC that pre-application conferences weren't being required?
Yes, and they not only held the conferences, but they also continued to submit the applications. And it wasn't just that we had told them that they were optional. We thought they were important but optional. But when they submitted the retail application, the site development permit for the retail application on November 22nd, and we gave them a letter of insufficiency on December 1st. Nowhere in that letter did it identify that the pre-application meeting had not taken place, and it didn't take place until December 5th.
So would the city have accepted submittal of IHIFC's applications even though a pre-application conference may not have occurred?
Exactly. That was not one of the criteria that we used in saying that their permit was insufficient.
Did the city tell other project applicants in the Issaquah Highlands that a pre-application conference was required?
Yes.
Did any other applicants object to this?
No.
I'd like to introduce a new exhibit. This is labeled Exhibit C60. For the record, this is another one-page multicolored chart. Ms. Sloman, are you familiar with this document?
Yes, I prepared it.
When did you prepare it?
Again, when we were preparing for rebuttal.
Could you please describe the content and context of this document?
Well, it really is illustrating the things that I just testified to, that on, you can see on the right, that in late October, Ms. Heim had challenged the requirement that either sometime in early November, Ms. Heim testified to the 6th. There was also an email on the 1st of November saying that pre-application conferences were optional. And you can see that they continued to both submit pre-apps such as for the office and the storage, and that continued to hold the meetings. So only the 2 pre-apps for the retail and the medical office were in prior to that conversation that said they weren't required.
Did you hear Ms. Heim's testimony concerning the sufficiency letters that the city sent in response to IHIFC's ASDP and SDP applications?
I did.
Are you familiar with exhibits of C16 through C26, where those sufficiency letters are located in this record?
More or less, yes.
Do you recall Ms. Heim's characterization of the sufficiency letters as, quote, nitpicky, end quote?
Yes.
You agree with that testimony and characterization?
No, I had actually talked to city staff and said that for anything that was coming in at the end of the development agreement, it was important to review them closely against the submittal requirements to ensure they were complete and everything that we needed was there prior to deeming them complete.
Would you explain why the city kept deeming IHIFC's land use permits insufficient under that standard?
Well, there were generally 2 reasons. One, in the beginning and even maybe towards the end, there were specific pieces of the proposal that were not provided as described on the submittal requirements. The second part was that there were elements that would be established through the preliminary plat process that that were represented as existing when they were, at this point, just proposed. And there was, as I mentioned earlier, a concern that some of those things in the preliminary plat were going to potentially change, and that the right-of-way, the property lines, the legal descriptions that they were showing might not, in fact, end up that way, and therefore the time that we had invested in reviewing these site development permits would be wasted, and we'd have to start over again.
Could you please turn to Exhibit S25, an exhibit that's already been entered into the record for this proceeding?
Got it?
Could you please turn to Appendix L and specifically page L-5 of that appendix?
Yes?
In the middle of the page, under a section heading 3 entitled Sufficient Application Decision, could you please read the text beginning with the second sentence and the words "as used in"?
As used, just that one sentence?
Please.
As used in this Appendix L, sufficient shall mean the required submission materials are sufficiently complete to allow continued processing.
Ms. Sloman, in your opinion and observation and experience, were IHIFC's various ASDP and SDP applications as submitted to the city sufficient under this standard?
No, as I testified, there were things that were uncertain or incomplete, and that could interfere with our ability to complete our review.
Was your decision to send the various sufficiency letters that, again, are listed at Exhibits C16 through C26 made in good faith?
Yes.
Did anyone direct you to send the sufficiency letters?
No, I consulted with Director Niven before I issued them, but no one was telling me to do that.
Thank you. Did you hear the testimony by the other witnesses concerning IHIFC's submission of its December 2017, quote, supplement, end quote, to its preliminary plat application?
Yes.
I believe that you've testified to this, but once more for the record, in your understanding, did this December 2017 submittal depict building footprints for future buildings on the project site?
Yes.
Did IHIFC ever mention this submittal to you or other city staff members before filing it?
Well, I don't know exactly about other staff members. I believe Ms. Lynn testified that she had not heard about it ahead of time, and I know I didn't, which surprised me when Ms. Heim testified as part of these proceedings that they, one of the reasons that they had submitted it was to assist in understanding where the buildings shown in the SDPs were relative to the parcel lines. It seemed to me that if that was the point, you would have let me know that it was coming in or had been submitted.
To your knowledge, was this submittal ever requested by the city?
No, not that I'm aware of.
I'd like to refer you back to Ms. Heim's testimony from the February 6, 2019 proceedings, and specifically to her statement in reference to this supplemental submission that, quote, "it has always been part of our application," end quote. Are you familiar with that statement?
I was here when she made it.
You agree with that statement?
If you're referring to, if that's referring to the building footprints, I would disagree with that because both the August 1st and I believe August 28th submittals did not include that.
Did IHIFC's December 2017 supplemental submittal depict or otherwise indicate the height of future buildings on the project site?
Not in the drawing set.
Was there anything in the associated narrative submitted with that document that would have indicated particular building heights?
Well, there was a general description that they might be, I think, up to 8 stories tall.
Was that in the original August submittal, or was that in the December submittal?
I believe that was in all, that part of the narrative was in all the submittals as I remember it.
And I'm sorry, you indicated that the possible intent was up to an 8-story building, was that correct?
Yes. With structured parking, I think.
So if I understand your testimony, IHIFC's plat narrative indicated that its future development plans for the property could include buildings up to 8 stories. Is that correct?
That's my memory, yes.
Would applying the replacement regulations prevent IHIFC from developing its property in the manner proposed by its August 2017 preliminary plat application?
No.
Could IHIFC still comply with the FAR standard imposed by the replacement regulations?
Sure, because I didn't know how tall the buildings were, and so it was not possible to calculate FAR, but it seems like it would be possible.
Could IHIFC still comply with the structured parking requirements?
Sure, some of those buildings might have been structured parking.
Thank you. Did you hear Ms. Heim's testimony regarding the city's alleged delay in reviewing and processing IHIFC's preliminary plat application?
Yes.
You agree with that testimony?
Could you be more specific? Which part?
Thank you. I believe that she was characterizing the length of time that the plat application has taken to be administratively processed as being essentially the city's fault, and I'm paraphrasing. Do you agree with that characterization?
No, I mean, we issued comments in, I think there were some engineering comments in January, and then electronic comments in March, and there were then a meeting and questions from IHIFC, which did take the city a long time to reply to, but then it was a back and forth of more and more questions, the last round of which did not seem directly related to, some of which did not seem directly related to the plat drawing corrections.
And the phrase "out for correction," quote unquote, was used several times in the testimony. Could you describe what that means in your understanding?
When we send comments to an applicant, we consider that permit out for corrections.
And what were the elements of IHIFC's plat application that required correction under this standard?
Well, I think we had some questions. I was not the reviewer on it, so I don't remember all the details. The main set of questions that I remember were around particularly Discovery Drive and which standard and which components it would have.
What is the current status of the IHIFC preliminary plat application?
It's been resubmitted
As of what date approximately?
sometime in March.
To what do you attribute the length of time that has been implicated in the review and processing of IHIFC's plat application?
Well, I mean, between March 2018 and March 2019, it was out for corrections. So there was a back and forth going on of questions and answers while we were waiting for the resubmittal.
Did you hear the testimony from the other witnesses suggesting that city staff allegedly targeted IHIFC's project proposals because they didn't like them?
Yes?
Do you agree with that testimony?
No.
Why not?
Well, part of the targeting related to the kind of regulations that were put into the replacement regulations. And the ones that they identified were things like minimum FAR and the structured parking, but those were in the drafts of the replacement regulations well before we had even seen any preliminary drawings from Shelter. And we had also put vesting provisions in place right around the same time that would have resulted, at least as proposed by staff at that time, that their permits would have been vested, so those provisions wouldn't have applied to them.
That was a staff recommendation.
Yes.
Did you hear the testimony from other witnesses suggesting that Mayor Pauley deliberately intended to target IHIFC?
Yes.
Do you agree with that characterization?
No.
Expand on that.
Well, I never heard her say anything to that effect.
Are you aware of any statements by Mayor Pauley that would support that allegation?
No.
Did Mayor Pauley ever direct you in any manner to thwart, delay, or otherwise oppose IHIFC's development proposals?
No.
Are you aware of any direction to that effect from Mayor Pauley made to any other City of Issaquah staff members?
No.
Approximately when was the 1.0 minimum floor area ratio, or FAR requirement, added to the replacement regulations?
In late September, 2017, sorry.
Was the inclusion of a 1.0 minimum FAR requirement in the replacement regulations intended to thwart or otherwise target IHIFC's proposal?
No, because we hadn't seen their proposals. We didn't know what it was going to be.
At the time, I think you just answered this, but I'll clarify that for the record. At the time the FAR requirement was added to the draft replacement regulations, had IHIFC submitted any development application to the city that would have been impossible to pursue under that FAR standard?
No, the size of their property and the amount of entitlement that they had purchased would have resulted in an FAR of about 2. So it seemed that they had enough entitlement to be able to achieve that.
And when was the FAR requirement first vetted with the Planning Policy Commission?
The draft was issued, I think, around September 21st, 2017, and then it was that draft was for their September 28th, 2017 meeting.
Thank you. I'd like to introduce a new exhibit. This, I believe, is Exhibit C61. And for the record, this is an email exchange that spans from October 24th, 2017 to November 1st, 2017. The most recent email being an email from Mr. Niven to Tia Heim with Gary Young and yourself listed as courtesy copy recipients, dated November 1st, 2017, and timed at 7:39 a.m. Are you familiar with this document?
Yes.
Could you please describe this document?
Well, after we had introduced the minimum FAR, there was discussions with Shelter Holdings about how it would apply to their property. And this email is a kind of back and forth as we're discussing, how it might be applied to their property, whether a variable FAR might be more acceptable to them. And so we were having that back and forth by email.
Okay. Would you characterize this email exchange as antagonistic or cooperative?
It seemed cooperative to me.
Approximately when was the structured parking requirement added to the draft replacement regulations?
Well, it was there from the beginning because we were relying on Central Issaquah for many of the regulations. But it was not, it was not overtly called out. We were just saying if something wasn't in the replacement regulations, then the Central Issaquah standards would be the default standard. However, the commissions, Urban Village Development Commission and Planning Policy Commission, wanted to have a better understanding of whether the Central Issaquah standards would be more strict or less strict or the same as the development agreements. And so in mid-September, we prepared a chart that showed going appendix by appendix from the development agreement, how the Central Issaquah standards compared, and that chart specifically said that the structured parking was stricter than the development agreement, the Issaquah Highlands development agreement.
And again, that general timeframe for making that an express provision of the replacement regulations?
Mid-September.
And if I understood your testimony, Ms. Sloman, I think you indicated that even before that, to use your words or to paraphrase them, that requirement was always intended to be part of the replacement regulations. Is that correct?
We had been saying since the earlier, in the spring of that year, that we would be relying on Central Issaquah as part of the standards that we would be using to create the replacement regulations.
Was the inclusion of a structured parking requirement in the replacement regulations intended to thwart or otherwise target IHIFC's development proposal?
No, we'd applied it in many different, it would already applied throughout Central Issaquah, and it was going to apply to all of the areas that the replacement regulations would apply to.
At the time the structured parking requirement was added to the draft replacement regulations, had IHIFC submitted any development application to the city that would have been impossible to pursue under the structured parking requirement?
No.
Do you recall the testimony regarding staff's proposed vesting language for the replacement regulations?
Sure. I don't know exactly which piece you're referring to.
For the vesting provision?
Yes.
What was staff's recommended vesting option for the city council?
Our initial recommendation was that pre-apps and land use permits that had been deemed complete would be vested.
Did the city council ultimately accept staff's recommendation?
No.
If the city council had accepted staff proposed vesting language in adopting the replacement regulations, what would have been the effect on IHIFC?
I don't think we'd be here today.
You expand on that?
Well, we might be here today, but because we would be reviewing their land use permits, but we wouldn't have been here for 15 nights going through all of these different aspects. We would have been focused on the land use permits because they would be in all likelihood, compliant with the regulations that they were being reviewed against.
So staff's preferred recommendation to the city council regarding vesting would have protected IHIFC's ASTP and STP applications in their original form, is that correct?
Relative to the specific provisions, minimum FAR, structured parking, and the plaza requirements, yes.
Did you hear the testimony from Ms. Heim and Mr. Young regarding Director Niven's alleged anger stemming from the landowner's decision against pursuing a college campus project on the Issaquah Highlands property?
Yes.
Did Mr. Niven ever express any such anger to you?
No, and he was frustrated and disappointed because he felt that they had, I think the terms he used was a gentleman's agreement, that they had been working together in good faith, and he was surprised that all of a sudden this had gone away.
Have you ever seen or heard anything from Mr. Niven indicating that he was attempting to foil or otherwise oppose IHIFC's development plans as a result of the college campus issue?
No.
Did you hear the testimony from Mr. Niven and the questioning of him by Mr. Schneider at the previous hearing regarding the planning profession ethical requirements?
Yes.
How long have you worked with Mr. Niven?
21 years next month.
In that 21-year period, have you ever observed Mr. Niven doing or saying anything that would violate those ethical standards?
No, and that's why he referenced those, because they're very important to him.
When did you learn that Polygon was purchased by Lion Homes and that the old Microsoft property was being split up?
I believe it was a newspaper article in 2014.
Did you hear the testimony from Ms. Heim and Mr. Young regarding the commissioning of the Kinzer report
Yes,
and the conclusions of that report?
yes.
Were you aware that Shelter had purchased the remainder of Port Blakely's entitlement?
Yes, because Port Blakely would send the changes in entitlement or purchasing of entitlement to me,
How did you become aware of this?
because they emailed the updated distribution of entitlement to me after those took place, including the one for Shelter Holdings.
And how much commercial entitlement under the 1996 development agreement did they acquire?
So when Polygon purchased the property from Microsoft, it was over 1.2 million square feet of commercial.
And how much residential entitlement was acquired?
They purchased 265 dwelling units from Port Blakely, and then another 100 transfer of development right units from a bank.
And how was entitlement addressed for purposes of the development agreement? Let me rephrase that. Was the entitlement specific to a particular property or portion of a property, or was it transferable to other areas covered by the development agreement?
Well, generally, you bought a piece of property and it without entitlement, you didn't have any. I mean, you could put a park on it or something, but I get the entitlement under the development agreement was possible throughout the whole property. So when you bought it, I suppose you could sell it to someone else.
Were you surprised to learn about the conclusions of the Kinzer report regarding the market support for particular land uses?
Yes, because the way I understood it from Ms. Heim's testimony was the Kinzer report did not support office or maybe commercial uses, and yet that was in maybe the middle of 2015, and then it was December 2015 that they were purchasing the rest of Port Blakely's commercial and retail entitlement, which was over 600,000 square feet.
And did Shelter itself own any residential entitlement?
They, when they bought the rest of the retail and commercial entitlement from Port Blakely, they also acquired 3 residential units.
Did you hear the previous, or the witness testimony regarding Mr. Niven's alleged attempts to take the residential entitlement away from Shelter?
Yes.
Do you agree with that testimony?
No, I think both Director Niven and I were kind of confused about what they were going to be able to do, make sense of 3 residential units, and we each at different times offered to convert that residential entitlement to commercial, but they declined, and under the replacement regulations, they still have 3 residential dwelling units.
Did you hear the other witness testimony suggesting greater numbers of residential units than 3?
Yes, Ms. Heim had mentioned, I think, 2,500 residential units at one point.
You agree with that testimony?
Well, yes and no. The way I remember it, Ms. Heim had described it as something from a report that they had received about what the market would bear. The way we had heard it or read about it was that that was part of a proposal that they had made to the Issaquah Highlands community.
Do you recall the testimony regarding the community outreach meetings conducted by Shelter during that period?
Yes.
Do you agree with the testimony concerning their characterization, or witnesses' characterization of those meetings?
Well, no, as I said, it sounded to me like that was just a report, but I did not attend the meetings. We decided that no staff would attend because those were Shelter's meetings with the community. But Issaquah Highlands has a newspaper called Connections, and also a weekly e-blast. And in those communication tools, they had reported on the meetings, and the way it was reported in those articles was that that was the proposal that was put forward to the community of 2,500 at the first meeting, and I believe 1,800 residential units at the second meeting.
I'm going to introduce into evidence 2 new exhibits. This is going to be entitled Exhibit C62 and C63. These are respectively excerpts from the Issaquah Highlands Connections publication that you just referred to. The first is dated July of 2016. The second is February of 2017. Could you please turn to the July 2016 document entitled Exhibit C62?
Yes.
Are you familiar with this document?
Yes, I read them when they came out.
Could you describe or explain and contextualize the description of IHIFC's proposal as depicted in this publication?
Well, I mean, I just landed on the first sentence of the second paragraph, which says the developer shared a proposal to build 2,500 residential units in a mixed-use configuration with retail and some medical offices. Attendees balked at the number of residential units and hoped for more commercial and retail development. So, and that was consistent with a few of the people that I spoke to.
And how many residential units did IHIFC or Shelter actually have at this point?
3.
And what was the proposal that they were vetting with the community at that time?
2,500.
So a fairly substantial increase?
Yes.
If their proposal had been ultimately pursued and approved?
Yes.
Could you then please turn to Exhibit C63. This is the Issaquah Highlands Connection excerpt from February of 2017.
Mm-hmm.
Are you familiar with this document?
Yes.
Could you please describe the content of this document as it relates to IHIFC's proposal?
This was describing that IHIFC had scaled back
64.
their proposal. So they were describing the meetings that took place in May and I believe, yes, in July, in which 2,500 residential units and then 1,800 residential units were proposed. And then where it says lay of the land, I believe that was laying out what they are planning to actually do, which is the entitlement that they purchased, as opposed to their request to change that entitlement to something different.
Did you hear the witness testimony previously concerning the community's response to IHIFC's proposal at that time?
I don't remember it in detail.
Let me rephrase the question then. To your recollection and understanding, what was the Issaquah Highland community's response to these community outreach meetings and the development proposals that IHIFC was vetting with the community at that time?
Some people were excited by the kind of, I think it was less about the residential and more about more restaurants and some of the amenities that they were proposing. But other people were concerned that there was this commitment to develop this non-residential commercial center, and they were concerned that they weren't going to get it.
Do you have any idea when Shelter learned that the Issaquah Highlands development agreement was going to be terminated?
I don't know exactly, but it seemed, on that big elaborate chart that I built, there are some there was a meeting that was identified as a development agreement meeting, which was in early, I think, 2015. And I believe early on, they began to negotiate and discuss whether a development agreement extension or new development agreement would be possible, but I don't know exactly the dates.
Were you involved in those discussions?
Very, very little. Almost exclusively, that was Director Niven and/or Emily Moon and Bob Harrison, other people.
And when approximately did IHIFC switch from pursuing the significant changes to their purchased entitlement to actually developing under the entitlement that they had actually acquired?
As I remember it, it was either late in 2016 or early in 2017 as the connection article that you see 63 indicated.
Why didn't the city just allow the conversion of some of IHIFC's commercial entitlement to the proposed residential use?
So the development agreement had an opportunity to convert, I think it was around maybe 800,000 square feet of commercial to 700 residential units. Port Blakely had fully exercised that conversion option. The residents we were hearing from had been waiting for 20 years for the live, work, play vision to be completed. Shelter had, at that point, about 65% of the commercial and 50% of the retail. So by converting to residential, it was, as the numbers in the articles indicate, significantly less commercial and retail than the entitlement that they possessed, and that was sort of part of the original vision. And, the last piece was that at this point, the city was really beginning, they wanted to complete the development agreement as envisioned, and the city had made a separate commitment when it became a regional growth center to focus quite a bit of residential development as well as commercial development on the valley floor, and And that may have even been part of ST3 station happening. And so there was a concern that, Shelter's property was greenfield development. Ms. Heim said that it was too easy for them to develop it in her testimony. And by that was kind of just a slice of what I said. Greenfield development is easier, and we felt it was really important that the city focus on the redevelopment of the valley floor and getting residential there, which is more difficult when you have to assemble property and deal with existing uses than it would have been if it had happened up at Issaquah Highlands. And so we really wanted to see the Issaquah Highlands development complete itself consistent with the original vision and let the Regional Growth Center be the focus of the new residential.
Thank you. One final question, Ms. Sloman. Are you familiar with the version of the development agreement for Issaquah Highlands that is contained at Exhibit S25, introduced into evidence for this proceeding by the applicant?
Yes?
Okay. Does that, to your understanding, reflect the most recent, complete, updated version of that development agreement?
No, what I noticed was that unlike the version of the development agreement that's currently posted on the city's website, it seemed to be the 20-year-old version and not the one that included the modifications and interpretations that had taken place over the years. That was the version that we had on the website.
I'm going to be introducing into evidence the city's final exhibit for this witness, and that's Exhibit C64. Ms. Sloman, could you please identify this document?
This is a printout of the development agreement that's on the city's website.
This is the version that the city holds out publicly on the city's website?
Yes.
Thank you. Mr. Chairman, that concludes my questioning for this witness, and I would yield to applicant's counsel.
Okay. Mr. Snyder?
I was distracted. Are you done, Zach?
Yes.
Yes, I'm done, Pat.
Okay. Ms. Sloman, let's start with Exhibit C64, the version of the Issaquah Highlands Annexation and Development Agreement that you have just described as being the one that's on the city's website. Has this version of the document ever been executed by the parties to the agreement?
I don't know what you mean by executed. Do you mean recorded?
No, I mean signed by the parties to the original agreement or their successors.
It was, no, it was incorporating approved modifications and interpretations, which the master developer had been a party to, but I don't think anyone ever signed the document.
Okay, because the version of C64 I've been given isn't signed, it isn't dated, and it has a bunch of red lines in it in a couple of different colors. So is it your opinion that this is a lawful regulatory document, or is it simply a reflection of evolving thinking by the city?
I wouldn't say it was evolving thinking by the city. It was trying to, at the point in time which it was created, incorporate modifications that were, because all modifications had to be joint between the master developer and the city was trying to incorporate project-wide modifications in a manner that would make it easier for both staff and applicants to use.
So how do we know that the developer agreed to any of this if it's not signed?
Well, my understanding is that where there are modifications, that they are frequently footnoted so that the specific modification or interpretation is identified.
Well, I'm not seeing any footnotes. Can you give us an example of what you're referring to?
Sure. So one example is on page L12, which is Appendix L, and the action memo at the bottom of that page is specifically called out.
Well, again, I'm not seeing a footnote. I'm seeing a highlighted paragraph, this one in blue. Many of the others are in red, and I think I saw a third color. And that paragraph concludes with a parenthetical, says, "See action memo," correct?
Yes.
How does repeat my question, how does anyone know whether all the parties who would have to approve modifications of the development agreement did so approve?
So I also noticed that the last pages of the document that you received include a list of modifications that have taken place that were included, both action memos, which are the interpretations, and administrative modifications. So that list is included at the very end. I have not cross-referenced it to determine that every single one of those is reflected, but that was a document to facilitate, as I said, applicant and staff use of the many modifications that had been approved over the course of the years.
Okay, well, is it fair to say that Exhibit S25, the excerpts from the development agreement that were already in the record, reflect as far as you know, the only version of the development agreement that was actually signed and executed by all the parties?
Okay, it's a signed document. It isn't necessarily a reflection of all the modifications that have taken place.
My question was, is S25, as far as you know, the only version of the development agreement that was signed by all the parties?
Sure.
And who created this document with all of these red lines and changes in it?
City staff.
What's the difference between the red type and the blue type?
I would assume that there were multiple staff working on incorporating these.
By the way, have any of the sections we've been talking about in this hearing been changed in this version in C64? Like section 323 dealing with vesting?
513 term has only been changed to update the name from Grand Ridge to Issaquah Highlands. In terms of 323, likewise, only the project name from Grand Ridge to Issaquah Highlands is shown as changed.
Okay, and when was this document C64 created?
I believe it was 2008.
And it was created by city staff in 2008?
Yes,
And were you working for the city in 2008?
yes.
I thought you were a consultant. Were you actually a city employee?
No, you're right, I was a consultant performing staff services for the city.
Okay, and when did you actually become a city employee again?
2012?
Has this been updated since 2008?
I don't believe so.
Ms. Sloman, Ms. Sloman, I want to turn back to the Vale project that Mr. Niven testified about last time, and you testified about this evening. My recollection of your testimony this evening is that the applicant was concerned about the moratorium and submitted a building permit application that the city deemed incomplete in an effort to vest before the moratorium took effect. Is that what you said?
It wasn't before the moratorium, well, I don't know if it took effect, but before they had the public hearing in which they set the terms of the final terms of the moratorium.
Well, the moratorium was in effect, it was adopted as an emergency ordinance, wasn't it? And it took effect immediately?
Yes, in September 6th.
And that happened before the submittal of the building permit application that you described, correct?
Well, the land use permit had already been submitted prior to September 6th. I don't know the date when it was submitted, but it would not have been going to commission by the end of September if it had been submitted after September 6th.
I'm going to ask you about the land use permits. Right now, it's correct, is it not, that the moratorium was in effect and the moratorium which prohibited new applications for building permits was in effect before the applicants made the submittal that you deemed incomplete?
Well, my understanding of moratorium, I was not the main person working with the council on this, but my understanding is that when you adopt a moratorium, you have to hold a public hearing, and that public hearing was when the final determination was going to be made about which projects could continue moving forward and which projects would be held up by the moratorium, and their concern was to be vested with a building permit prior to that public hearing.
Okay. We're going to offer a series of exhibits now. The next one is what?
While we do that, Mr. Lell, you were saying that you had to leave at 8:30?
Yes, thank you, Mr. Chairman. I just received a text indicating that other hearing is running behind, so I'm kind of waiting for them to re-engage. So yeah, I didn't want to share our own experience here, but I assume that they're dealing with an equally complex, lengthy issue.
When it's time for you to go, would you just get up and go? Is that, we don't need to take a break?
I'll be happy to turn this over to my colleague and return when the conference is over. Thank you.
We were going to take a break at 8:30. Is this a reasonable time, or?
Sure, we can mark the exhibits while we do that.
Okay, would you do that, please? Let's take a 10-minute break. Okay, I'd like to call the meeting back to order.
Solomon, I'm going to hand you a copy of what we've marked as Exhibit S-120, which is, I represent to you a copy of the moratorium ordinance.
Okay?
What's the date on this?
The Vale property you and Mr. Niven have both testified about is within the geographic area subject to this moratorium, correct?
Yes.
And this moratorium, if we turn to Section 2, it imposes a moratorium on permit applications, which are defined as building permits or land use applications limited to administrative site development permits, plats, and short plats, correct?
That's what it says.
And then if we turn to Section 8, declaration of emergency, it basically says the moratorium shall take effect immediately and shall remain effective for 6 months unless terminated earlier by the city council. Is that accurate?
That's what Section 8 says.
Okay, and so what is the date that it took effect then?
I'm sorry, say that again?
What is the date the moratorium took effect?
Uh, 9/6/2016.
The date it was signed, September 6, 2016.
Yes.
So the next exhibit is S-21, which is, I represent to you a copy of the notice of application for the Vale project for the land use SUPs. Is that accurate?
That's what it appears to be.
And what is the date of that land use application?
April 19th, 2016.
And I'm going to hand you now a copy of, did I give away my copy of? There we go. I'm going to hand you a copy of S-122, which is, I represent a copy of the notice of decision for that same land use application. Is that accurate?
That's what it appears to be.
And so what is the date of that land use decision?
October 25th, 2016.
What is the date of the decision on the application?
Well, I'm looking on the front page, and it says approval date, October 25th, 2016. Are you referring to a different date?
If I can see what I just handed you.
Sure.
Thank you. And now I'm going to hand you a copy of S-123, which I submit is a copy of the building permit application for the Vale Apartments. Did you confirm that's accurate?
That's not the permit I'm referring to. This is a later permit that they submitted in 2017. The permit that I'm referring to was submitted, I believe, October 14. If you look at S-120, in Section 5, Public Hearing, the public hearing was scheduled for October 17th, 2016, and my memory is that somewhere maybe around October 14, 2016, or sometime before that date of October 17th, they submitted another building permit with the purpose of being vested prior to the public hearing that would modify the terms of the moratorium.
Well, I'm going to offer a copy of another building permit application in a moment right now, Ms. Sloman, but I'm asking you to confirm that this is in fact, the exhibit I just handed you, Exhibit 123, is in fact the building permit application that the city accepted, processed, and eventually approved for the Vale Apartments.
Yes,
And that application was submitted after the land use decision was issued, correct?
yes,
In conformity with the, what the requirements stated on the city's website require, that you submit your building permit application after you get your notice of decision on the land use application, correct? That's the chronology that happened with the Vale Apartments.
Well, you're supposing that we are using the submittal requirements as a regulatory document, which we weren't. But yes, the chronology that the notice of decision for the land use permit was approved in October, and the permit, the building permit that was ultimately issued was submitted in January 2017. Yes, that is correct.
Okay. And the reason I'm pointing that out is that Mr. Niven last time testified that the city had accepted the building permit before the land use decision was issued. And the chronology that we've just established by the official permit that the city accepted, agreed was complete and processed is different, correct?
But that's not the permit that we're talking about.
Well,
I mean, yes, that is the permit that was issued, but that's not the permit we're referring to.
Okay, and if one goes to the city's website and looks to see what is the date of the building permit application for the Vale Apartments, it gets the date in January of 2017, correct?
I haven't been to the website, so I don't know. I assume it's because they withdrew that first one, ultimately.
Handing you a copy of Exhibit 124. Is this the building permit application you're referring to?
I believe so.
Okay, and what date, what does it tell us about this application? What was the application date?
October 14th, 2016.
And that is more than a month after the effective date of the moratorium?
Yes, but before the public hearing on the moratorium.
Well, the moratorium doesn't say it doesn't take effect until after the public hearing, does it?
No.
The moratorium was in effect beginning on September 6th, and this building permit application that you've been talking about was submitted on October 14th, correct?
Yes.
When the moratorium was in effect.
Okay.
And I'm not aware of anything in the law, city code, state statute, or anything else that says that a moratorium doesn't take effect until the public hearing, when the public hearing is held after the effective date of the moratorium. Are you aware of any such authority?
I'm not an expert on moratoria.
Okay. And what is the status of the application you've been talking about, which is Exhibit S-124?
It was ultimately withdrawn.
Well, what does the city's permit say its status is?
Canceled.
Now, Ms. Sullivan, I want to make sure I heard correctly your testimony earlier this evening about when you learned that an applicant, and I put the word learned in quotation marks, but when it became your understanding that an applicant cannot vest a process, when did that happen?
I'm not sure. Sometime after the development agreement was adopted, sometime maybe that summer.
I thought you testified either late August or early September. Did I misremember?
The conversation that I had with Director Niven was in late July, early August.
Excuse me, late July, early August. And is that the conversation where you remember him telling you that an applicant cannot vest a process?
Well, I don't think we were discussing it in that particular way. I think what we were discussing was which set of regulations for processing your client's land use permits, which process would apply.
Well, now I'm not focusing on the process for the land use permits. I'm asking you when you learned that a vested application does not vest a process. When did that become your opinion?
I actually don't know.
Okay, so you processed all of the polygon applications that you've been talking about and that are demonstrated on the charts you introduced this evening. You processed all of those applications under the process in the development agreement, correct?
Yes.
And that included taking the applications for the plat and for other applications as well to the UVDC, correct?
Yes.
You wrote a letter to my client on April 5th, which is, we made it an exhibit last time in this proceeding. I think it's exhibit S112, telling her that you were going to process our client's plat under the procedures in the replacement regulations?
Yes.
So is it fair to assume that you came up with that opinion that we weren't vested to process before April 5th of this year?
Yes.
How much before that did you come to that opinion?
I really don't know.
Well, are we talking days, weeks, months, years?
Maybe, I would be guessing. I don't have an answer. I don't remember.
Well, you continued to process all of Polygon's applications under the procedures in the development agreement. So you treated Polygon as vested to process until at least March of this year, did you not?
Yes, that was my error.
So, well, then, when did you decide that it was an error?
I don't remember.
Okay, well, did you continue processing Polygon's applications as vested even though you had decided it was an error? Or did you decide it was an error after you finished processing their applications?
I really don't remember. I understand why you're asking. I don't have an answer.
What changed your mind about vesting so that Polygon is vested to process and IHIFC is not? If you can't answer the question when, I'm now asking the question why. Why did you change your mind? What happened?
I don't know. I would guess that because we are, for your applicant's permits, we are consulting more regularly with the city attorney. That may have been the reason that I became aware that I had made this error.
When did you consult with the city attorney?
Well, I consult with the city attorney quite often. I don't necessarily know which conversation was specifically related to this topic.
So it's your testimony, Ms. Solomon, that you cannot recall when you had a conversation with the city attorney that changed your mind about vesting to process?
That is my testimony.
Okay. And did you consult with the city attorney before you wrote your April 5th letter telling IHIFC that it was not vested to process?
Yes.
Did you consult with the city attorney before writing your April 15th letter, which is in the record as exhibit? It's S-114, which I think is an email that attaches your April 15th letter? S-113, excuse me. If you could turn to that, please. I'm going to ask you a number of questions about exhibit S-113.
I don't think I have that here. This one stops at 111.
Can't get rid of this.
You have a copy now?
I do.
Okay. And again, you consulted with the city attorney before writing both your April 5th and your April 15th letter?
Yes.
Did you consult with Mr. Niven before writing either letter?
Which letter were you asking about?
Either one.
There was, I believe, he was aware that they were happening. One of them was sent during a time when he was out of the office, so he was aware that I was working with the city attorney. I don't know if he reviewed it.
Well, did Mr. Niven decide that IHIFC is not vested to process before you wrote either of these letters?
He may have. I don't know exactly what he knew when.
Well, Ms. Sloman, we've had testimony, and the code expressly says that it's Mr. Niven who makes vesting determinations for the city, not the city attorney, correct?
It's Mr. Niven in consultation with the city attorney.
Right, but it's Mr. Niven who makes the determination, not the city attorney, correct?
Okay.
And Mr. Niven testified in this hearing, you were present for it, that one does vest a process. Don't you remember that?
I don't.
Well, we had Mr. Niven read his testimony at the last hearing. We can go back and do it again if you want. Why don't we go back to his original testimony, which is in the October 24th transcript, page 23.
October 24th?
Yes.
Okay, I'm at page 23 of the transcript.
So why don't we start why don't I read my questions and you can read Mr. Niven's answers. And I'm going to start with page 23, line 4, in the middle of one of my questions. Question, so if one vests to the development agreement, including Exhibit L, which is the process part of the development agreement, correct?
That's my recollection, yes.
Okay, then your department, in fact, has treated people who have vested to the development agreement as vested to the process in Appendix L, correct?
Mr. Niven's answer is yes.
And you have done that for multiple polygon projects, for example.
Yes.
So you knew that Mr. Niven had testified that his department was treating people who vested to the development agreement, in particular Polygon, as vested to the process in Appendix L, correct?
I can't say that I remembered this testimony when we were working on these letters.
Well, but you also didn't consult with Mr. Niven, who is the official responsible for vesting determinations, before you sent either letter, did you?
No, that's not what I said. I believe it was the first letter that I was speaking with him. I believe it was the second letter when he was out of town, but I consulted with him before he left town.
Well, when you consulted with him, did you ask him to determine whether or not my client was vested to process?
I don't think I worded it that way, no.
Okay, so what do you remember consulting with Mr. Niven about, if it wasn't whether my client was vested to process?
Well, we were talking about the preliminary plat and that I don't remember how events unfolded. We had received the resubmittal from your applicant, your client in March, and we were preparing to move forward. I don't remember what the event was that triggered this conversation or exactly who I spoke to when about it. I would not have sent a letter to your client without having consulted with both the director and the city attorney.
Okay, my recollection of Mr. Niven's testimony from our last hearing on April 30th, and I'm refreshing my recollection by looking at the transcript, which I'll ask you to look at in a moment, but my recollection is he didn't arrive at the opinion that my client is not vested to process until we had a 10-minute break and he consulted with the city attorney in the middle of this hearing. Did I misunderstand what happened last time?
I don't know. I don't have that transcript in front of me, and I'm unclear why I'm being asked to speak for when Mr. Niven knew a piece of information.
Well, you're being asked these questions, Ms. Sloman, because you wrote letters, 2 of them, to my client saying they are not vested to process, when it is Mr. Niven who is responsible for that determination. And as far as I can tell from Mr. Niven's testimony, he didn't agree with it until the middle of the last hearing, long after both letters were sent. That's why I'm asking these questions. Would you turn, please, to the transcript from the last hearing? I hope it's in your binder, the April 30th transcript.
Okay.
And All right, let's turn, please, to page 110.
Okay.
Actually, it's, yeah, page 110. I'm going to read the questions again. I'm going to ask you to read Mr. Niven's answers. And I'm going to start with line 4, my question. Question, and you treated Polygon as vested to Appendix L of the development agreement, and you're telling this commission now, after you met with the city attorney, that my client is not vested, even though they're completely similarly situated, correct?
And Mr. Niven said, I didn't say I think they're similarly situated.
My question, my response was, no, I added that.
Mr. Niven said you did.
Question, so if they're not similarly situated, what's the difference?
Mr. Niven said I would have to consult with my staff on that.
Question, so as you stand here tonight, Mr. Niven, there's no lawful basis for distinguishing them, and yet you're treating one as vested and one as not. Is that correct?
Mr. Niven said I don't know that answer.
Question, why not?
Mr. Niven said because I don't know what the lawful reason is why they were treated differently from a processing standpoint.
Question, well, Mr. Niven, you just met with the city attorney and came out and told us that it was, you agreed that my client was not vested, yet you treated Polygon as vested. So I'm asking you, what is the basis for your distinction treating one differently than the other?
Mr. Niven said, I think we're back to third rail.
Question, so you're blaming the city attorney again on your conduct?
Mr. Niven said, I'm saying that the city attorney is helping me to make decisions pursuant to the code.
Question, but it's your decision, Mr. Niven. You've already agreed that you are responsible. So you have no reason for doing or saying what you're saying other than that you met with Mr. Lell over a 10-minute break here tonight, right?
Mr. Niven said, I'm saying that what my response is to the difference in processing is a result of conversations with the city attorney. Yes.
Question, okay, and you have no other grounds for saying what you're saying?
Mr. Niven said, I have no other grounds.
Okay, so despite the testimony that we just went through from Mr. Niven, and despite his earlier testimony in October that one does vest a process, it's your testimony tonight that Mr. Niven made the decision before April 5th that my client is not vested to process, and that's why you wrote the letter?
I consulted with Mr. Niven and the city attorney before writing the letters. Mr. Niven knew that I was going to be writing those letters. He may have reviewed the first letter, I don't remember. I don't know how else to answer your question.
Okay, well, so did Mr. Niven give you any reason for treating my client differently than Polygon in terms of vesting to process?
We didn't discuss that.
I thought that's what we were just talking about. Didn't you just tell us that you consulted with Mr. Niven and he approved or otherwise agreed with your letter saying we're not vested to process?
Yes, but we weren't doing that within the context of Polygon, which was the part of the content of your question.
So you didn't discuss with Mr. Niven why you're treating my client completely differently than Polygon, even though they're both vested to their plat applications?
When you say they're both vested to their plat applications, could you tell me who they are?
Well, you've treated Polygon as vested for all of its applications, but this specific direct comparison that I'm now drawing is between the two plat applications. The Polygon Single Family North application submitted in July of 2017 and Shelter's application submitted on August 1st of 2017. they were both deemed vested by the city and by Mr. Niven, correct?
They were both deemed complete and therefore vested, yes.
Okay, so we're now talking about an application, two applications that the city has agreed, the city has agreed that both applications are vested to the development agreement. The city has decided that one of those applications is vested to process and one is not. And you're testifying that when you wrote this letter saying my client is not vested, there was absolutely no discussion between you and Mr. Niven of why you're saying that to my client and you didn't say that to Polygon?
I think we were mainly focused on your permit. I can't say, I don't remember whether we discussed Polygon at the time or not.
Let's turn to your April 15th letter. Ms. Sloman, did you write this letter?
In consultation with the city attorney.
Have you read the cases that you cited in the letter?
No.
Well, it's a little hard to ask you questions about assertions you made about cases if you haven't read the cases, Ms. Sloman. So you put me under a bit of a handicap by making statements that you have no knowledge whether they're accurate or not. But I'm going to represent to you that one of the cases that you rely upon doesn't even address the issue that we're talking about, and the other case is one that actually directly contradicts the position you're taking. Are you familiar, you haven't read, do you know anything about the facts in the R.C. Hadreen Company versus City of Seattle case?
No.
Well, that's a case that I'm very familiar with because I was the lead attorney for the city on that case. And in fact, what the court held in that case is that Mr. Hadreen was vested to the procedures in the city's landmark ordinance. If I'm accurately representing what the case says, how does that support your position that my client is not vested to the procedures in the development agreement?
I rely on my city attorney to provide me with legal advice, and I would not be able to answer that question.
Okay. Is there any part of this letter that you wrote as opposed to the city attorney wrote?
Mr. Chairman, I'm going to respectfully object to that. I mean, this is really getting into the attorney-client privilege. The fact that there may have been consultations between city staff and the city attorney's office, it can be a public record to the extent that staff discloses that, but the content of those communications and the extent to which particular documents may have been co-authored by legal counsel is certainly within that third rail previously referenced by Mr. Niven. I would strongly object to this line of questioning.
And the city has waived the attorney-client privilege many times over. It is tactically asserting the privilege as a defense, which is not permitted under the law. The only explanation we have been given is that the attorneys made this decision, not Mr. Niven, and we're not. And so we've been told that you're supposed to rely on it. It's reasonable because it's following the advice of the attorney, but we aren't able to question or inquire into that advice. It's entirely inappropriate. The privilege has been waived, and my question, despite all that, my question was whether she wrote any part of this. That is not asking for advice.
And I would respectfully reiterate my objection, Mr. Chairman. The city has not waived the attorney-client privilege in these proceedings and has certainly not done that tactically or selectively in the manner suggested by Mr. Schneider. This is clearly within the attorney-client privilege as well established in Washington law, and the witness should not be forced to answer that question.
Well, I would suggest, since you are not a court with jurisdiction over this issue,
That's correct.
that what we do is I be allowed to ask the questions I think are appropriate. And if Mr. Lell wants to direct the witness not to answer, he can do so. That will create an appropriate record for judicial review.
Okay. That probably is the course of action we should take.
Okay,
Thank
so
you.
my question, Ms. Sloman, was, is there any part of this letter that you wrote as opposed to the city attorney writing?
Ms. Sloman, I would recommend that you would advise you not to answer that question.
I'm following my city attorney's direction.
I'm sorry?
I'm going to follow my city attorney's direction.
Okay. So, Ms. Sloman, on the first page, you cite a code section from the replacement regulations, 1819B280, which says, and we've talked about it many times, you are familiar with this code section, correct?
Yes?
Okay, and one of the ways in which someone vests under the replacement regulations is by means of a development agreement, correct?
That is one of the actions that's listed there, yes.
Okay, and the city has acknowledged that my client is vested by virtue of its plat application to the development agreement, correct?
To the extent that my city attorney tells me that that is the case.
I'm sorry, you think we're only vested to the development agreement to the extent your city attorney tells you we are?
I am consulting with the city attorney to confirm how, when we end a development agreement and we establish vesting provisions in the replacement regulations, how those are applied.
Well, Ms. Sloman, I'm struggling a bit. I thought it was undisputed, and the city had acknowledged from the outset, including in Mr. Niven's famous April 4th, 2018 letter, that my client is vested to the subdivision application.
And my understanding from the city attorney is that we are vested, that you are vested to certain standards related to the plat, but not to procedures and some other standards.
Okay, and again, is there anything in any city code or state statute that you know of that says you vest to some parts of a development agreement and not to others?
That is my understanding based on conversations with the city attorney.
Okay, and I just want to clarify, you're not aware of any other basis for that other than what your city attorney has told you, correct?
Well, I understand that's based on case law.
Which you haven't read, correct?
Correct.
Have you ever seen any case that says one cannot vest to procedures?
I don't read case law. I rely on the city attorney to consult staff on current case law.
I apologize, there's been argument. Okay, Ms. Sloman, I'm going to hand you a copy of the case that you cited but haven't read in your letter, the R.C. Hadreen Company versus City of Seattle case. And I'm going to point you to the paragraph that includes the quote that is in your letter, which is from the first sentence of that paragraph. And then I'm going to ask you to go down and, well, first of all, I'm going to well, rather than ask you to read this, Ms. Sloman, I'm going to think better of it and just tell you again what I represented to you earlier, and I'm going to quote from the language right now. Your letter quotes the first sentence of that paragraph that says, the vested rights doctrine protects developers against the effect of new regulations, not proceedings authorized by existing regulations. Do you recognize that sentence from your letter? It's at the top of first full paragraph on the top of page 3. The question is simply, is that the sentence that you quoted in your letter?
That sentence is in this letter, yes.
Okay. And if you continue on in that same paragraph, it's talking about what the developer vested to in that case, and it says he vested to the landmarks ordinance, and which was enacted pursuant to the procedures set forth in the ordinance. So more specifically, the designating ordinance about which the developer was complaining was enacted pursuant to the procedures set forth in the ordinance that he vested to. So the court is saying he was vested to the procedures in the landmarks
Mr.
ordinance.
Chairman, I'm going to have to respectfully object again. This is legal argument, and Mr. Counsel's quoting from a case and expecting the witness apparently to respond to that. She's already testified multiple times that she's not an attorney, and she has not, as she indicated in her testimony, has not read the cases. I don't know where this line of questioning is going to, but it seems much more appropriate to closing legal argument than it does questioning the factual witness.
And I agree the question was awkward, but it points out the absurdity of the situation that the city's tactical assertions of privilege are putting us in here. We've had repeated objections in this proceeding that I am asking for legal questions or asking for legal opinions, yet the city doesn't hesitate to submit a letter that is written by the city attorney and that is full of legal opinions that this person signing the letter hasn't read. And then when I ask about the letter, I can't get any answers because it's a legal issue, and she's not an attorney and hasn't read the opinion she's citing. It's another example of why the city's use of the attorney-client privilege in this case is completely inappropriate, but I am prepared to move on.
Thank you.
So I want to go down a little bit further on page 3 of your letter, Ms. Sloman. And the fourth paragraph, the third full paragraph, talks about the Urban Village Development Commission. And you basically say, and I'm going to quote from your letter here, you say that it's a practical impossibility for IHIFC to have its plat processed in front of the Urban Village Development Commission, correct? The words practical impossibility are a quote from what is written in this letter, correct?
I'm looking for that phrase. I'm not, I apologize, I'm not seeing it.
It's the fourth line of the third full paragraph.
It's the fourth line of the third full paragraph. Oh, I see it now, thank you.
Mr. Chairman, if I could, please, I do need to recuse myself now briefly for a phone conference. I should be back within approximately 20 minutes. I apologize for the intrusion.
Thank you.
Mr. Dunbar will take over for me.
Thank you.
Pardon me.
Okay, Ms. Sloman, again, you referred to the UVDC process as a practical impossibility.
I see that that text appears here, yes.
Is that your language?
I don't remember.
When was the last meeting of the UVDC?
The March 26, 2019 meeting referred to in the next paragraph?
Okay, and explain to us all the reasons why it's a practical impossibility for the UVDC to process my client's application.
Well, I think that there are two things. The UVDC is not actively engaged right now, but I think the other piece is that we believe that the proper procedures to process the plat is the replacement regulations, which would send it to another entity.
So I think the second reason you gave is a repetition of the legal assertion you've been making. I want to focus on the practical impossibilities.
Okay.
So what, again, makes it a practical impossibility? In fact, for example, the UVDC didn't terminate, did it?
No.
Sorry?
I said no.
Okay. And in fact, the UVDC is created by the city council, and only the city council can terminate it, correct?
Yes.
And its March 26th meeting was not its last, was it?
I don't think of another meeting since March 26th.
Well, I listened to the end of the video of the March 26th meeting, and it says the commission is adjourning until August. Isn't that correct?
I believe you're referring to the closing motion, which was what to do with the minutes of that final meeting if it did not reconvene. And August was given as the date by which, if it did not reconvene, that the chairperson and I would were given a mechanism to, we were authorized to approve the minutes. There was no meeting established.
Okay, so you a couple of times said if the UVC didn't reconvene, there's nothing preventing it from reconvening except your decision not to process my client's plat application in front of it, is there?
No, we just barely have a quorum, but yes.
Okay, so why is it a practical impossibility as stated in this letter if you just acknowledged the only thing preventing it from hearing the application is your decision not to have it do that?
Because there's no other business in front of it.
Because you've decided that my client's application, unlike all of Polygon's applications, is not vested to process, correct?
Okay. It was, as I've repeatedly said, it was an error. And the process that we proposed to your client is in the replacement regulations, and you stated last time that that process is worse. And we do not consider that worse. We consider it better. That's why we proposed it.
Well, I respectfully disagree with your memory of what you think I said last time, Ms. Sloman, but in any event, what happened is that you wrapped up Polygon's applications under the UVDC on March 26th, and 5 days later, having concluded Polygon's applications vested to process, you write a letter to my client saying they're not vested to process. Isn't that exactly what happened?
No, the March 26th meeting had nothing to do with processing their plat application. The plat application meeting for Parcel D was in December, and it went to council in January or February. The March 26th meeting was a separate matter, not related to their plat.
And I didn't refer to a plat in my question, Ms. Sloman. I referred to Polygon's applications. You wrapped up 5 days before you wrote the letter to my client all of Polygon's applications, which you treated as vested to process, and then you wrote a letter to my client saying you're not vested to process, correct?
So I'm not quite sure why we're conflating the March 26th meeting with, that was a very unique meeting that we held with the Urban Village Development Commission, and it was based on a plat condition. It was not based on vesting.
Yes, it was based on a condition of Polygon's High Street plat, correct?
Yes,
Okay, and High Street was required to be converted as a condition of their plat, correct?
yes,
So Polygon was the applicant, and the hearing was being conducted pursuant to their plat application because it was a condition of approval of that plat, correct?
that was not a hearing. It was a public meeting.
Excuse me, a public meeting. It was nonetheless a public meeting under the procedures that you treated Polygon as vested to in the development agreement, correct?
Their plats were we treated as vested under the Issaquah Highlands Development Agreement.
And all of their applications went to the UVDC, obviously including the one that was at issue on March 26, correct?
That was a public meeting. That was not, there's nothing in the development agreement about a public meeting. That was not based on the development agreement or vesting. It was a subsidiary activity that came out of the plat.
Yes, it was a condition of their plat application that went to the UVDC because you treated all their applications as vested to the procedures in the development agreement, correct?
And we could have specified that it go to the Development Commission. That was not an outgrowth of how those plat permits were processed.
Ms. Sloman, on March 26, the UVDC conducted what you're referring to as a public meeting that was required as a condition of Polygon's plat, correct?
Yes,
5 days after that meeting on Polygon's, that was a condition of Polygon's plat application, you send a letter to my client saying that you send a letter to my client saying we're going to treat you differently than we've been treating Polygon for the last year and 3 months, and we're going to send you to the Development Commission instead of the UVDC, correct?
no, the letter did not refer anything about Polygon and how we had processed their permits.
No, the letter doesn't mention that. The letter doesn't acknowledge that you're treating my client differently than Polygon. But nonetheless, it's a 5-day difference between a meeting of the UVDC about Polygon's applications and your letter to my client saying you're not going to the UVDC. Can you not accept that as a fact?
I can accept that there was, I don't know whether it was 5 days. I thought it was April 5th, but yes, approximately a week to 8 days between those two events.
Okay. And again, can you give any explanation for that differential treatment other than advice of the city attorney that you're not telling us about?
I made an error in how I processed Polygon's permits.
Well, Ms. Sloman, you only made an error if, based on what you're now saying was advice of the city attorney that you won't tell us about, correct?
I don't even understand your question.
Okay, why do you think you made an error? Is there any reason for you to assert that other than the advice of the city attorney?
Advice of the city attorney that I made an error? Is that what you're asking me? That I discovered the error because of advice from the city attorney?
That's one way to rephrase the question.
In the process of So the March 26th meeting, I don't think is germane to this. I understand you disagree with me. The processing of the plat and was concluded at the UVDC in December and the City Council in January or February. Sometime after that, after your client resubmitted their plat, I realized that I had processed those permits in error. I don't remember the exact course of events. I don't remember who brought that to my attention. I don't have the level of detail that you're asking me to reconstruct at this moment.
I think my question, Ms. Sloman, you've already told us some while ago that you couldn't remember when you decided you had made an error. I'm not asking that question again. I'm asking whether there is any basis for your testimony that you made an error other than advice from the city attorney.
Well, if I don't remember the conversation that identified when I came to realize that I made that error, it is difficult for me to know whether that was speaking with the city attorney, speaking with Mr. Niven, something that happened within these proceedings. I don't remember.
Well, Ms. Sloman, I'm asking you about events that happened within the last 2 months at most, apparently. You've been testifying in detail and at length about events that happened years ago. So are you really saying you can't remember who you talked to and when you made the decision that you were in error?
Mr. Chair, I'm going to respectfully object to this questioning. The witness has answered the question multiple times. Simply asking the same question over and over again, trying to elicit a different response is not going to be productive.
Okay,
I will move on.
thank you.
So I want to offer a new exhibit. It's a code section. Put it up on the screen, Jackie, 1803045. This is exhibit we believe it's S125.
I believe that's correct. The top of my pile is S-124.
Okay.
Did you say 1803-05?
045.
045.
I'm handing out a copy. So are you familiar with this code section, Ms. Sloman?
Yes?
So, putting it up on the screen as well, but this says, does it not, the Urban Village Development Commission, the UVDC that we've been talking about, shall act, review project approvals as provided in the Issaquah Highlands Development Agreement. Correct?
Yes?
And the Issaquah Highlands Development Agreement includes Appendix L, which is the process, correct?
Yes?
So, since the development agreement that the city acknowledges my client is vested to includes Appendix L and includes the procedure in front of the UVDC, your decision to send my client's application to the Development Commission violates this code section, does it not?
I would not agree because the replacement regulations specifically directed that things like preliminary plats were processed by the Development Commission and the hearing examiner.
Ms. Solomon, the replacement regulations say one of the three ways you can vest after the termination of the development agreement is by means of a development agreement, correct?
I think this is the crux of why we're here, is that the city and your client disagree about the applicability of the replacement regulations, which set of standards apply. I'm not sure that in answering your question, I'm going to be able to address what you're asking me to address.
Nonetheless, I would request that you answer my question, Sloman.
Would you repeat it, please?
The replacement regulations say that one of the ways you can vest is by means of a development agreement, correct?
Yes?
And the development agreement we've been talking about since last September is a development agreement that not only includes vesting language, it also includes procedures, correct?
Say that again, I'm sorry.
The Issaquah Highlands Development Agreement includes procedures as well as substantive regulations, correct?
I agree that the Issaquah Highlands Development Agreement includes procedures.
Okay, and so now we're talking about a new statute, a new ordinance rather, that we haven't talked about previously because it doesn't specifically mention vesting. And this ordinance says that the Urban Village Development Commission shall act to review project approvals as provided in the Issaquah Highlands Development Agreement, correct?
That's what 1803045A says, yes.
Okay, and your letter talking about vested rights, your letter with the case citations that you haven't read doesn't address this section, does it?
No.
So can you offer any explanation for why, when the city council has declared that the UVDC shall review project approvals as provided in the development agreement. Why you're not doing that?
Because the development regulations that were adopted more recently say something different.
Ms. Sloman, 1803045A is in the code, isn't it?
It is.
It hasn't been repealed, just like the city council hasn't repealed the UVDC, correct?
Correct.
Have you had any conversations with Mr. Niven about your April 15th letter since you sent it?
Probably. I mentioned that it had been sent. I don't, is there a specific thing that you're wondering if I've talked to him about?
I'm wondering whether he agrees with it. Have you had a conversation with him, since he's the city's official who makes vesting determinations?
I have not asked him if he agrees with it.
Well, Ms. Slovan, when you gave the notice of application for my client's plat, what did you say about the process in that notice of application? Well,
I don't, because I didn't prepare that.
have you done anything to update the notice of application that your office sent out January of 2018 for the plat application?
So I take that back. I prepared some of the text, and I don't remember exactly what that said. That was a notice of application that was issued. I think we worked on it. There were 3 notice of applications that were sent out in December 2017, and I worked on the text. I don't remember what it said, and we haven't updated it because we would typically do that when we send out the notice for hearing on the preliminary plat.
So when are you going to send out the notice of hearing on my client's plat application?
Well, we would have to, I think we've been waiting to hear back on the second letter. You seem to disagree about that, so we have not written that until we have concluded that discussion.
You're waiting to hear back from my client in response to your April 15th determination?
Well, you've taken issue with it in these proceedings, and so it seemed that there might be more that you wanted to say in response to that letter.
Well, Ms. Sloman, you decided in consultation with the city attorney, apparently, that my client is not vested and that you're going to process it under by sending it to the by not sending it to the UVDC, and now you're doing nothing, what, waiting for the outcome of this hearing, or what?
No, I'm not doing nothing, but I have not scheduled, it wouldn't be a hearing, it would be a community conference, and I have not scheduled that community conference, partly because I am waiting to see when these procedures have concluded, to know when the Development Commission would have a date, and partly because this is a proceeding in which your client would be expected to participate, and I want to confirm that.
Well, Ms. Sloman, my understanding is, as the city has been arguing for over a year, is that we can't challenge Mr. Niven's vesting determination, assuming this is Mr. Niven's vesting determination, until this proceeding ends and we appeal to the hearing examiner. Hasn't that been the city's position for over a year?
So just to make sure I'm understanding your question, are you saying for these land use permits that the appeal of the decision on these land use permits will not happen until a decision is issued?
Oh, my question is specific to Mr. Niven's vesting determinations. We have been trying, as Mr. Lell himself demonstrated by offering a bunch of exhibits that reflect the decisions of the hearing examiner, we have been trying to appeal Mr. Niven's vesting determination since he put it in his April 4th, 2018 letter. And the city so far has successfully prevented us from doing that by saying we have to wait first until Mr. Niven put his vesting determination in the staff reports to this commission, and then until the commission concludes this proceeding, and only then can we commence an appeal of those vesting determinations. Isn't that a fair summary of the city's position since April of last year?
Relative to the land use permits?
Relative to the vesting determinations that this hearing has been about.
Yes, that to appeal those, we need a decision to be issued.
Okay, so you've now made a vesting determination in this letter that, according to the city's year-long position, we can't appeal or do anything about until this hearing is concluded. So why are you waiting on a response to your letter? Are you going to change your mind if we tell you we don't agree?
So the first step under the replacement regulations would be to hold a community conference at the Development Commission. That would not be a decision. That would be a public consultation with the commission and the community. Subsequent to that, we would go to the hearing examiner with a staff report and recommendation.
Okay, so have you attempted to schedule that hearing with the Development Commission?
It is not a hearing, it is a community conference, and we had in our first letter offered we asked your client for some input about the dates of these proceedings and the dates of the community conference, I believe, and so that was not discussed. So we are assuming that we're waiting until after these proceedings are concluded before we try and schedule another matter with the Development Commission.
Okay, well, what I'm trying to find out, Ms. Sloman, is whether my client's plat application is going to sit with the city doing nothing until we have commenced and concluded an appeal to the hearing examiner, or whether you are going to go ahead and act pursuant to the vesting determination set forth in your two letters.
So I'm not, just because we have not scheduled something with the Development Commission does not mean that we are doing nothing.
What are you doing?
I have been reviewing the documents and developing the list of items that we are supposed to take to the Development Commission.
Okay. So when do you think you're going to be ready for this community meeting then?
As I said, we currently have a very full schedule between these proceedings and another permit that is at the Development Commission. It may be later in June or early July. I do not have the schedule memorized.
It's 10 o'clock. I have a whole series of exhibits that were offered for the first time tonight to question Ms. Sloman about, but this might be a good breaking point.
No objection, Mr.
All
Commissioner.
right. We have reached the agreed-upon time to adjourn tonight's meeting, and we'll be continuing the public hearings on tonight's agenda to May 15th. I believe that all the commissioners are available on the 15th. And I would just offer or ask if the parties have an estimate of whether they will be able to wrap up their witnesses on May 15th or whether we need to schedule another meeting.
The city does not intend to call any further rebuttal witnesses, so our case is effectively closed at this point.
Well, as I said last time, we do have rebuttal witnesses. We have a ways to go with Ms. Sloman. I think it's possible we will finish next time, but I can't be certain.
Track record would indicate that we probably ought to be looking at scheduling another meeting. Just saying. So let's try to do that.
We began that process today.
Great, okay. So the public hearing on tonight's agenda will continue a special meeting of the commission on May 15th in the council chambers at 6:30. The meeting is now adjourned.